This is the notes for the MPRE, starting with 1.1, competence. A lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. 1.2, scope of representation and allocation of authority. A. Subject to paragraphs C and D, a lawyer shall abide by a client's decisions concerning the objectives of representation, and as required by Rule 1.4, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as is impliedly authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter. In a criminal case, the lawyer shall abide by the client's decision after the consultation with the lawyer as to a plea to be entered, whether to waive a jury trial, and whether the client will testify. B. A lawyer's representation of a client, including the representation by appointment, does not constitute an endorsement of the client's political, economic, social, or moral views or activities. C. A lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. D. A lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with the client and may counsel or assist the client to make a good faith effort to determine the validity, scope, meaning, or application of the law. 1.3, diligence. A lawyer shall act with reasonable diligence and promptness in representing a client. 1.4, communications. A lawyer shall 1. Promptly inform the client of any decision or circumstance with respect to which the client's informed consent as defined by Rule 1.0e is required by these rules. 2. Reasonably consult with the client about the means by which the client's objectives are to be accomplished. 3. Keep the client reasonably informed about the status of the matter. 4. Promptly comply with reasonable requests for information. And 5. Consult with the client about any relevant limitation on lawyer's conduct when the lawyer knows that the client expects assistance not permitted by the rules of professional conduct or the law. B. A lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. 1.5, fees. A. A lawyer shall not make an arrangement for, charge, or collect an unreasonable fee or an unreasonable amount for expenses. The factors to be considered in determining the reasonableness of a fee include the following. 1. The time and labor required, the novelty and difficulty of the questions involved, and the skill requisite to perform the legal service properly. 2. The likelihood, if apparent to the client, that the acceptance of the particular employment will preclude other employment by the lawyer. 3. The fee customarily charged in the locality for similar legal services. 4. The amount involved in the results obtained. 5. The time limitations imposed by the client or by the circumstances. 6. The nature and length of the professional relationship with the client. 7. The experience, reputation, and ability of the lawyer or lawyers performing the services. And 8. Whether the fee is fixed or contingent. B. The scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible shall be communicated to the client, preferably in writing, before or within a reasonable time after commencing the representation, except when the lawyer will charge a regularly represented client on the same basis or rate. Any changes in the basis or rate of the fee or expenses shall also be communicated to the client. C. A fee may be contingent on the outcome of the matter for which the service is rendered, except in a matter in which a contingent fee is prohibited by paragraph D or other law. A contingent fee agreement shall be in writing, signed by the client, and shall state the method by which the fee is to be obtained, including the percentage or percentages that shall accrue to the lawyer in the event of settlement, trial, or appeal. Litigation and other expenses to be deducted from the recovery. and whether such expenses are to be deducted before or after the contingent fee is calculated. The agreement must clearly notify the client of any expenses for which the client will be liable, whether or not the client is the prevailing party. Upon conclusion of a contingent fee matter, the lawyer shall provide the client with a written statement stating the outcome of the matter, and, if there is a recovery, showing the remittance to the client and the method of its determination. D. A lawyer shall not enter into an agreement for, charge, or collect 1. Any fee in a domestic relations matter, the payment or amount of which is contingent upon securing of a divorce or upon the alimony or support, or property settlement in lieu thereof, or 2. A contingent fee for representing a defendant in a criminal case. E. A division of a fee between lawyers who are not in the same firm may be made only if 1. The division is in proportion to the services performed by each lawyer, or each lawyer assumes joint responsibility for the representation. 2. The client agrees to the arrangement, including the share each lawyer will receive, and the agreement is confirmed in writing. 3. The total fee is reasonable. 1.6. Confidentiality of information. A. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. Paragraph B. A lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes is necessary. 1. To prevent reasonably certain death or substantial bodily harm. 2. To prevent the client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interests or property of another, and in furtherance of which the client has used or is using the lawyer's services. 3. To prevent, mitigate, or rectify substantial injury to the financial interests or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, in furtherance of which the client has used the lawyer's services. 4. To secure legal advice about the lawyer's compliance with these rules. 5. To establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. To establish a defense to a criminal charge or civil claim against the lawyer based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of the client. 6. To comply with other law or a court order. 7. To detect and resolve conflicts of interest arising from the lawyer's change of employment or from changes in the composition or ownership of a firm, but only if the revealed information would not compromise the attorney-client privilege or otherwise prejudice the client. C. A lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of unauthorized access to information relating to the representation of a client. 1.7. Conflicts of interest, current clients. A. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if 1. The representation of one client will be directly adverse to another client, or 2. There is a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, or a third person by personal interest of the lawyer. B. Notwithstanding the existence of a concurrent conflict of interest under paragraph A, a lawyer may represent a client if 1. The lawyer reasonably believes that the lawyer will be able to provide competent and diligent representation to each affected client. 2. The representation is not prohibited by law. 3. The representation does not involve the assertion of a claim by one client against another client represented by the lawyer in the same litigation or other proceeding before a tribunal. And 4. Each affected client gives informed consent confirmed in writing. 1.8. Current client-specific rules. A. A lawyer shall not enter into a business transaction with a client or knowingly acquire an ownership, possessory, security, or other pecuniary interest adverse to a client unless 1. The transaction and terms on which the lawyer acquires the interest are fair and reasonable to the client and are fully disclosed and transmitted in writing in a manner that can be reasonably understood by the client. 2. The client is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent counsel on the transaction. 3. The client receives informed consent in a writing signed by the client to the essential terms of the transaction and the lawyer's role in the transaction, including whether the lawyer is representing the client in the transaction. B. A lawyer shall not use information relating to the representation of a client to the disadvantage of the client unless the client gives informed consent, except as permitted or required by these rules. C. A lawyer shall not solicit any substantial gift from a client, including a testamentary gift, or prepare on behalf of a client an instrument giving the lawyer or person related to the lawyer any substantial gift unless the lawyer or other recipient of the gift is related to the client. For purposes of this paragraph, related persons include a spouse, child, grandchild, parent, grandparent, or other relative or individual with whom the lawyer or client maintains a close familial relationship. D. Prior to the conclusion of the representation of a client, a lawyer shall not make or negotiate an agreement giving the lawyer literary or media rights to a portrayal or account based in substantial part on information relating to the representation. E. A lawyer shall not provide financial assistance to a client in connection with pending or contemplated litigation, except that 1. A lawyer may advance court costs and expenses of litigation, the repayment of which may be contingent on the outcome of the matter. 2. A lawyer representing an indigent client may pay court costs and expenses of litigation on behalf of the client. And 3. A lawyer representing an indigent client pro bono, a lawyer representing an indigent client pro bono through a nonprofit legal service, or public interest organization, and a lawyer representing an indigent client pro bono through a law school, clinical, or pro bono program may provide modest gifts to the client for food, rent, transportation, medicine, and other basic living expenses. The lawyer, 1. May not promise, assure, or imply the availability of such gifts prior to retention or as an inducement to continue the client-lawyer relationship after retention. 2. May not seek or accept reimbursement from the client, a relative of the client, or anyone affiliated with the client. And 3. May not publicize or advertise a willingness to provide such gifts to prospective clients. Financial assistance under this rule may be provided even if the representation is eligible for fees under a fee-shifting statute. F. A lawyer shall not accept compensation for representing a client from one other than the client unless 1. The client gives informed consent. 2. There is no interference with the lawyer's independence of professional judgment or with the client-lawyer relationship. And 3. Information relating to the representation of a client is protected as required by Rule 1.6. G. A lawyer who represents 2 or more clients shall not participate in making an aggregate settlement of the claims of or against the clients, or in a criminal case an aggregated agreement as to guilty or nolo contendere pleas, unless each client gives informed consent in a writing signed by the client. The lawyer's disclosure shall include the existence and nature of all the claims or pleas involved and of the participation of each person in the settlement. H. A lawyer shall not 1. Make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement, or 2. Settle a claim or potential claim for such liability with an unrepresented client or former client unless that person is advised in writing of the desirability of seeking and is given reasonable opportunity to seek the advice of independent legal counsel in connection therewith. Opportunity to seek the advice of independent legal counsel in connection therewith. I. A lawyer shall not acquire property interests in the cause of action or subject matter of litigation the lawyer is conducting for a client, except that the lawyer may 1. Acquire a lien authorized by law to secure the lawyer's fee or expenses, and 2. contract with the client for a reasonable contingent fee in a civil case. J. A lawyer shall not have sexual relations with the client unless a consensual sexual relationship existed between them when the client-lawyer relationship commenced. K. While lawyers are associated in a firm, a prohibition in the foregoing paragraphs A through I that applies to any one of them shall apply to all of them. 1.9. Duties to former clients. A. A lawyer who has formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of a former client, unless the former client gives informed consent confirmed in writing. B. A lawyer shall not knowingly represent a person in the same or substantially related matter in which a firm with which the lawyer formerly was associated had previously represented a client, one whose interests are materially adverse to that person, and two, about whom the lawyer had acquired information protected by Rules 1.6 and 1.9c that is material to the matter, unless the former client gives informed consent confirmed in writing. C. A lawyer who has formerly represented a client in a matter, or whose present or former firm has formerly represented a client in a matter, shall not thereafter, 1. Use information relating to the representation to the disadvantage of the former client, except as these rules would permit, require with respect to a client, or when the information has become generally known, or 2. Reveal information relating to the representation, except as these rules would permit or require with respect to a client. 1.10. Imputation of conflicts of interest. A. While lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by Rules 1.7 or 1.9 unless 1. The prohibition is based on a personal interest of the disqualified lawyer and does not present a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm. 2. The prohibition is based upon Rule 1.9a or B and arises out of the disqualified lawyer's association with the prior firm. And 1. The disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom. 2. Written notice is promptly given to any affected former client to enable the former client to ascertain compliance with the provisions of this rule, which shall include a description of the screening procedures employed, a statement of the firm's and of the screen lawyer's compliance with these rules, a statement that review may be available before a tribunal, and an agreement by the firm to respond promptly to any written inquiries or objections by the former client about the screening procedures, and 3. Certifications of compliance with these rules and with the screening procedures are provided to the former client by the screen lawyer and by a partner of the firm at reasonable intervals upon the former client's written request and upon termination of the screening procedures. B. When a client is terminated in association with the firm is not prohibited from thereafter representing a person with interests materially adverse to those of a client represented by the formerly associated lawyer and not currently represented by the firm, unless 1. The matter is the same or substantially related to that in which the formerly associated lawyer represented the client. 2. Any lawyer remaining in the firm has information protected by Rules 1.6 and 1.9c that is material to the matter. C. A disqualification prescribed by this rule may be waived by the affected client under the conditions stated in Rule 1.7. D. The disqualification of lawyers associated in a firm with former or current government lawyers is governed by Rule 1.11. Rule 1.11. Special conflicts, former and current government employees. A. Except as law may otherwise expressly permit, a lawyer who has formerly served as a public officer or employee of the government, 1. is subject to Rule 1.9c, and 2. shall not otherwise represent a client in connection with the matter in which the lawyer personally participated and substantially has as a public officer or employee, unless the appropriate government agency gives its informed consent confirmed in writing to the representation. B. When the lawyer is disqualified from representation under paragraph A, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in such matters unless 1. The disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom. 2. Written notice is promptly given to the appropriate government agency to enable it to ascertain compliance with the provisions of this rule. C. Except as law may otherwise expressly permit, a lawyer having information that the lawyer knows is confidential government information about a person acquired when the lawyer was a public officer or employee may not represent a private client whose interests are adverse to that person in a matter in which the information could be used to the material disadvantage of that person. As used in this rule, the term confidential government information means information that has been obtained under governmental authority and which, at the time this rule is applied, the government is prohibited by law from disclosing to the public or has a legal privilege not to disclose and which is not otherwise available to the public. A firm with which that lawyer is associated may undertake or continue representation in the matter only if the disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom. D. Except as law may otherwise expressly permit, a lawyer currently serving as a public officer or employee, 1. is subject to Rules 1.7 and 1.9, and 2. shall not 1. participate in a matter with which the lawyer participated personally and substantially while in private practice or non-governmental employment, unless the appropriate government agency gives its informed consent confirmed in writing, or 2. negotiate for private employment with any person who is involved as a party or as lawyer for a party in a matter in which the lawyer is participating personally and substantially, except that a lawyer serving as a law clerk to a judge or other adjudicative officer or arbitrator may negotiate for private employment as permitted by Rule 1.12b and subject to the conditions as stated in Rule 1.12b. E. As stated in this rule, the term matter includes 1. any judicial or other proceeding, application, request for a ruling or other determination, contract, claim, controversy, investigation, charge, accusation, arrest, or other particular matter involving the specific party or parties, and 2. any other matter covered by the conflict of interest rules of the appropriate government agency. Rule 1.12. Former judge, arbitrator, mediator, or third-party neutral. A. Except as stated in paragraph D, a lawyer shall not represent anyone in connection with the matter in which the lawyer participated personally and substantially as a judge or other adjudicative officer or law clerk to such a person, or as arbitrator, mediator, or other third-party neutral, unless all parties to the proceeding give informed consent confirmed in writing. B. A lawyer shall not negotiate for employment with any person who is involved as a party or as lawyer for a party in a matter in which the lawyer is participating personally and substantially as a judge or other adjudicative officer, or as an arbitrator, mediator, or other third-party neutral. A lawyer serving as a clerk to a judge or other adjudicative officer may negotiate for employment with the party or lawyer involved in a material in which the clerk is participating personally and substantially, but only after the lawyer has notified the judge or other adjudicative officer. C. If a lawyer is disqualified by paragraph A, no lawyer in a firm with which that lawyer is associated may knowingly undertake or continue representation in the matter unless 1. the disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom, and 2. written notice is promptly given to the parties in any appropriate tribunal to enable them to ascertain the compliance with the provisions of this rule. D. An arbitrator selected as partisan of a party in a multi-member arbitration panel is not prohibited from subsequently representing that party. Rule 1.13. Organization as client. A. A lawyer employed or retained by an organization represents the organization acting through its duly authorized constituents. B. If a lawyer or an organization knows that an officer, employee, or other person associated with the organization is engaged in action, intends or acts or refuses to act in a manner related to the representation that is a violation of a legal obligation to the organization, or a violation of law that reasonably might be imputed to the organization and that is likely to result in substantial injury to the organization, then the lawyer shall proceed as is reasonably necessary in the best interest of the organization. Unless the lawyer reasonably believes that it is not necessary in the best interest of the organization to do so, the lawyer shall refer the matter to a higher authority in the organization, including, if warranted by the circumstances, to the highest authority that can act on behalf of the organization as determined by applicable law. C. Except as provided in paragraph D, if 1. Despite the lawyer's efforts in accordance with paragraph B, the highest authority that can act on behalf of the organization insists upon or fails to address in a timely and appropriate manner an action or refusal to act that is clearly a violation of law, and 2. The lawyer reasonably believes that the violation is reasonably certain to result in substantial injury to the organization, then the lawyer may reveal information relating to the representation whether or not Rule 1.6 permits such disclosure, and only if and to the extent the lawyer reasonably believes necessary to prevent substantial injury to the organization. D. Paragraph C shall not apply with respect to information relating to a lawyer's representation of an organization to investigate an alleged violation of law, or to defend the organization or an officer, employee, or other constituent associated with the organization against a claim arising out of an alleged violation of law. E. A lawyer who reasonably believes that he or she has been discharged because of the lawyer's actions taken pursuant to paragraphs B or C, or who withdraws under the circumstances that require or permit the lawyer to take an action under either of those paragraphs, shall proceed as the lawyer reasonably believes necessary to assure that the organization's highest authority is informed of the lawyer's discharge or withdrawal. F. In dealing with an organization's directors, officers, employees, members, shareholders, or other constituents, a lawyer shall explain the identity of the client when the lawyer knows or reasonably should know that the organization's interests are adverse to those of the constituents with whom the lawyer is dealing. G. A lawyer representing an organization may also represent any of its directors, officers, employees, members, shareholders, or other constituents subject to the provisions of Rule 1.7 if the organization's consent to the dual representation is required by Rule 1.7. The consent shall be given by an appropriate official of the organization other than the individual who is to be represented or by the shareholders. Rule 1.14. Client with diminished capacity. A. When a client's capacity to make adequately considered decisions in connection with the representation is diminished, whether because of minority, mental impairment, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship with the client. B. When the lawyer reasonably believes that the client has diminished capacity, is at risk of substantial physical, financial, or other harm, unless action is taken and cannot adequately act in the client's own interest, the lawyer may take reasonably necessary protective action, including consulting with individuals or entities that have the ability to take action to protect the client, and, in appropriate cases, seeking the appointment of a guardian ad litem, conservator, or guardian. C. Information relating to the representation of a client with diminished capacity is protected by Rule 1.6. When taking protective action pursuant to paragraph B, the lawyer is impliedly authorized under Rule 1.6a to reveal information about the client, but only to the extent reasonably necessary to protect the client's interests. Rule 1.15. Safekeeping property. A. A lawyer shall hold property of clients or third persons that is in a lawyer's possession in connection with the representation separate from the lawyer's own property. Funds shall be kept in a separate account maintained in the state where the lawyer's office is situated, or elsewhere with the consent of the client or third person. Other property shall be identified as such and appropriately safeguarded. Complete records of such accounts, funds, and other property shall be kept by the lawyer and shall be preserved for a period of 5 years after the termination of the representation. B. A lawyer may deposit the lawyer's own funds in a client's trust account for the sole purpose of paying bank service charges on that account, but only in an amount necessary for that purpose. C. A lawyer shall deposit into a client's trust account legal fees and expenses that have been paid in advance to be withdrawn by the lawyer only as fees are earned or expenses incurred. D. Upon receiving funds or other property in which a client or third person has an interest, a lawyer shall promptly notify the client or third person. Except as stated in this rule or otherwise permitted by law or by agreement with the client, a lawyer shall promptly deliver to the client or third person any funds or other property that the client or third person is entitled to receive and, upon request by the client or third person, shall promptly render a full accounting regarding such property. E. When in the course of representation the lawyer is in possession of property in which two or more persons, one of whom may be the lawyer, claim interest, the property shall be kept separate by the lawyer until the dispute is resolved. The lawyer shall promptly distribute all portions of the property as to which the interests are not in dispute. Rule 1.16. Declining or terminating representation. A. Except as stated in paragraph C, a lawyer shall not represent a client or, where representation has commenced, shall withdraw from representation of a client if 1. The representation will result in violation of the rules of professional conduct or other law. 2. The lawyer's physical or mental condition materially impairs the lawyer's ability to represent the client. 3. The lawyer is discharged. Paragraph B. Except as stated in paragraph C, a lawyer may withdraw from representing a client if 1. Withdrawal can be accomplished without material adverse effect on the interests of the client. 2. The client persists in a course of action involving the lawyer's services that the lawyer reasonably believes is criminal or fraudulent. 3. The client has used the lawyer's services to perpetuate a crime or fraud. 4. The client insists upon taking an action that the lawyer considers repugnant or with which the lawyer has a fundamental disagreement. 5. The client fails substantially to fulfill an obligation to the lawyer regarding the lawyer's services and has been given reasonable warning that the lawyer will withdraw unless the obligation is fulfilled. 6. The representation will result in an unreasonable financial burden on the lawyer or has been rendered unreasonably difficult by the client. Or 7. Other good cause for withdrawal exists. Paragraph C. A lawyer must comply with applicable law requiring notice to or permission of a tribunal when terminating a representation. When ordered to do so by a tribunal, a lawyer shall continue representation notwithstanding good cause for terminating the representation. D. Upon termination of representation, a lawyer shall take steps to the extent reasonably practicable to protect a client's interests, such as giving reasonable notice to the client, allowing time for employment of other counsel, surrendering papers and property to which the client is entitled, and refunding any advance payment or fee or expense that has not been earned or incurred. The lawyer may retain papers relating to the client to the extent permitted by other law. Rule 1.17. Sale of law practice. A lawyer or a law firm may sell or purchase a law practice or an area of law practice, including goodwill, if the following conditions are satisfied. Paragraph A. The seller ceases to engage in the private practice of law or in the area of practice that has been sold, in the geographic area, in the jurisdiction. Jurisdiction may elect either version, in which the practice has been conducted. Paragraph B. The entire practice or the entire area of practice is sold to one or more lawyers or law firms. Paragraph C. The seller gives written notice to each of the seller's clients regarding 1. The proposed sale, 2. The client's right to retain other counsel or take possession of the file, and 3. The fact that the client's consent to the transfer of the client's files will be presumed if the client does not take any action or does not otherwise object within 90 days of receipt of notice. If a client cannot be given notice, the representation of that client may be transferred to the purchaser only upon entry of an order so authorizing by a court having jurisdiction. So authorized by a court having jurisdiction. The seller may disclose to the court in camera information relating to the representation only to the extent necessary to obtain an order authorizing the transfer of a file. D. Paragraph D. The fees charged clients shall not be increased by reason of the sale. Rule 1.18. Duties to prospective client. Paragraph A. A person who consults with a lawyer about the possibility of informing a client-lawyer relationship with respect to a matter is a prospective client. Paragraph B. Even when no client-lawyer relationship ensues, a lawyer who has learned information from a prospective client shall not use or reveal that information, except as Rule 1.9 would permit, with respect to information of a former client. C. A lawyer subject to paragraph B shall not represent a client with interests materially adverse to those of a prospective client in the same or substantially related matter if the lawyer received information from the prospective client that could be significantly harmful to that person in the matter except as provided in paragraph D. If a lawyer is disqualified from representation under this paragraph, no lawyer in a firm with which that lawyer is associated may knowingly undertake continue representation in such a matter, except as provided in paragraph D. Paragraph D. When the lawyer has received disqualifying information as defined in paragraph C, representation is permissible if 1. Both the affected client and the prospective client have given informed consent confirmed in writing, or 2. The lawyer who received the information took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine whether to represent the prospective client, and 1. The disqualified lawyer is timely screened from any participation in the matter and is apportioned no part of the fee therefrom, and 2. Written notice is promptly given to the prospective client. Rule 2.1 Advisor. In representing a client, a lawyer shall exercise independent professional judgment and render candid advice. In rendering advice, a lawyer may refer not only to the law, but to other considerations such as moral, economic, social, and political factors that may be relevant to the client's situation. Rule 2.3 Evaluation for use by third persons. Paragraph A. A lawyer may provide an evaluation of a matter affecting a client for the use of someone other than the client if the lawyer reasonably believes that making the evaluation is compatible with other aspects of the lawyer's relationship with the client. Paragraph B. When the lawyer knows or reasonably should know that the evaluation is likely to affect the client's interests materially and adversely, the lawyer shall not provide the evaluation unless the client gives informed consent. Paragraph C. Except as disclosure is authorized in connection with the report of an evaluation, information relating to the evaluation is otherwise protected by Rule 1.6. Rule 2.4 Lawyer serving as a third-party neutral. Paragraph A. A lawyer serves as a third-party neutral when the lawyer assists two or more persons who are not clients of the lawyer to reach a resolution of a dispute or other matter that has arisen between them. Service as a third-party neutral may include service as an arbitrator, a mediator, or in such other capacity as will enable the lawyer to assist the parties to resolve the matter. Paragraph B. A lawyer serving as a third-party neutral shall inform unrepresented clients that the lawyer is not representing them. When the lawyer knows or reasonably should know that a party does not understand the lawyer's role in the matter, the lawyer shall explain the difference between the lawyer's role as a third-party neutral and a lawyer's role as one who represents a client. Rule 3.1 Meritorious Claims and Contentions. A lawyer shall not bring or defend a proceeding or assert or controvert an issue therein unless there is a basis in law and fact for doing so that is not frivolous, which includes a good faith argument for an extension, modification, or reversal of existing law. A lawyer for the defendant in a criminal proceeding or the respondent in a proceeding that could result in incarceration may nevertheless so defend proceeding as to require that every element of the case be established. Rule 3.2 Expediting Litigation. A lawyer shall make reasonable efforts to expedite litigation consistent with the interests of the client. Rule 3.3 Candor toward the Tribunal. Paragraph A. A lawyer shall not knowingly 1. Make a false statement of fact or law to a tribunal or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. 2. Fail to disclose to the tribunal legal authority in the controlling jurisdiction known to the lawyer to be directly adverse to the position of the client and not disclosed by opposing counsel. Or 3. Offer evidence that the lawyer knows to be false. If a lawyer, the lawyer's client, or a witness called by the lawyer has offered material evidence and the lawyer comes to know of its falsity, the lawyer shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. A lawyer may refuse to offer evidence other than the testimony of a defendant in a criminal matter that the lawyer reasonably believes is false. Paragraph B. A lawyer who represents a client in an adjudicative proceeding and who knows that a person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct related to the proceeding shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. Paragraph C. The duties stated in paragraphs A and B continue to the conclusion of the proceeding and apply even if compliance requires disclosure of information otherwise protected by Rule 1.6. Paragraph D. An ex parte proceeding. A lawyer shall inform the tribunal of all material facts known to the lawyer that will enable the tribunal to make an informed decision, whether or not the facts are adverse. Rule 3.4. Fairness to opposing party and counsel. A lawyer shall not, paragraph A, unlawfully obstruct another party's access to evidence or unlawfully alter, destroy, or conceal a document or other material having potential evidentiary value. A lawyer shall not consult or assist another person to do any such act. Paragraph B. Falsify evidence. Counsel or assist a witness to testify falsely or offer an inducement to a witness that is prohibited by law. Paragraph C. A lawyer shall not knowingly disobey an obligation under the rules of a tribunal except for an open refusal based on an assertion that no valid obligation exists. Paragraph D. A lawyer shall not, in pretrial procedure, make a frivolous discovery request or fail to make reasonably diligent effort to comply with the legally proper discovery request by an opposing party. Paragraph E. A lawyer shall not, in trial, allude to any matter that the lawyer does not reasonably believe is relevant or that will not be supported by admissible evidence. Assert personal knowledge of facts and issue except when testifying as a witness, or state a personal opinion as to the justness of a cause, the credibility of a witness, the culpability of a civil litigant, or the guilt or innocence of an accused. Paragraph F. A lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to another party unless 1. The person is a relative or an employee or other agent of a client. 2. The lawyer reasonably believes that the person's interests will not be adversely affected by refraining from giving such information. Rule 3.5. Impartiality and decorum of the tribunal. The lawyer shall not, paragraph A, a lawyer shall not seek to influence a judge, juror, prospective juror, or other official by means prohibited by law. Paragraph B. A lawyer shall not communicate ex parte with such a person during the proceeding unless authorized to do so by law or by court order. Paragraph C. A lawyer shall not communicate with the juror or prospective juror after discharge of the jury if 1. The communication is prohibited by law or court order. 2. The juror has made known to the lawyers a desire not to communicate. Or 3. The communication involves a misrepresentation, coercion, duress, or harassment. Or, paragraph D, a lawyer shall not engage in conduct intended to disrupt a tribunal. That doesn't make sense. Okay. Rule 3.6. Trial publicity. Paragraph A. A lawyer who is participating or who has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communication and will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. Paragraph B. Notwithstanding paragraph A, a lawyer may state 1. The claim, offense, or defense involved, except when prohibited by law, the identity of the persons involved. 2. Information contained in a public record. 3. That an investigation of a matter is in progress. 4. The scheduling or result of any step in litigation. 5. A request for assistance in obtaining evidence and information necessary thereto. 6. A warning of danger concerning the behavior of a person involved when there is reason to believe that there exists the likelihood of substantial harm to an individual or to the public interest. And 7. In a criminal case, in addition to subparagraphs 1 through 6, 1. The identity, residence, occupation, and family status of the accused. 2. The accused has not been apprehended. Information if the accused has not been apprehended, information necessary to aid in apprehension of that person. 3, the fact, time, and place of an arrest. 4, the identity of investigating and arresting officers or agencies, and the length of the investigation. Paragraph C. Notwithstanding paragraph A, a lawyer shall make a statement that a reasonable lawyer would believe is required to protect a client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. Paragraph D. No lawyer associated with the firm or government agency with the lawyer subject to paragraph A shall make a statement prohibited by paragraph A. Rule 3.7. Lawyers as witnesses. Paragraph A. A lawyer shall not act as advocate at a trial in which the lawyer is likely to be a necessary witness unless 1. The testimony relates to an uncontested issue, 2. The testimony relates to the nature and value of legal services rendered in the case, or 3. Disqualification of the lawyer would work substantial hardship on the client. Paragraph B. A lawyer may act as advocate in a trial in which another lawyer in the lawyer's firm is likely to be called as a witness unless precluded from doing so by Rule 1.7 or Rule 1.9. Rule 3.8. Special responsibilities of a prosecutor. The prosecutor in a criminal case shall, paragraph A, refrain from prosecuting a charge that the prosecutor knows is not supported by probable cause. Paragraph B, the prosecutor in a criminal case shall make reasonable efforts to assure that the accused has been advised of the right to and the procedure for obtaining counsel and has been given reasonable opportunity to obtain counsel. Paragraph C, the prosecutor in a criminal case shall not seek to obtain from an unrepresented accused a waiver of important pretrial rights, such as the right to a preliminary hearing. Paragraph D, the prosecutor in a criminal case shall make timely disclosure to the defense of all evidence or information known to the prosecutor that tends to negate the guilt of the accused or mitigates the offense, and, in connection with sentencing, disclose to the defense and to the tribunal all unprivileged mitigating information known to the prosecutor, except when the prosecutor is relieved of this responsibility by a protective order of the tribunal. Paragraph E. The prosecutor in a criminal case shall not subpoena a lawyer in a grand jury or other criminal proceeding to present evidence about a past or present client unless the prosecutor reasonably believes 1. The information sought is not protected from disclosure by an applicable privilege, 2. The evidence sought is essential to the successful completion of an ongoing investigation or prosecution, and 3. There is no other feasible alternative to obtain the information. Paragraph F. The prosecutor in a criminal case shall, except for statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose, refrain from making extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused, and exercise reasonable care to prevent investigators, law enforcement personnel, employees, or other persons assisting or associated with the prosecutor in a criminal case from making an extrajudicial statement that the prosecutor would be prohibited from making under Rule 3.6, or this rule. Paragraph G. A prosecutor in a criminal case shall, when a prosecutor knows of new, credible, and material evidence creating a reasonable likelihood that a convicted defendant did not commit an offense of which the defendant was convicted, the prosecutor shall 1. Promptly disclose that evidence to an appropriate court or authority, and 2. If the conviction was obtained in the prosecutor's jurisdiction, 1. Promptly disclose that evidence to the defendant unless the court authorizes delay, and 2. Undertake further investigation or make reasonable efforts to cause an investigation to determine whether the defendant was convicted of an offense that the defendant did not commit. Paragraph H. When a prosecutor knows of clear and convincing evidence establishing that a defendant in the prosecution's jurisdiction was convicted of an offense that the defendant did not commit, the prosecutor shall seek to remedy the conviction. Rule 3.9. Advocate in non-adjudicative proceedings. A lawyer representing a client before a legislative body or administrative agency in a non-adjudicative proceeding shall disclose that the appearance is in a representative capacity and shall conform to the provisions of Rules 3.3a through C, 3.4a through C, and 3.5. Rule 4.1. Truthfulness and statement to others. In the course of representing a client, a lawyer shall not knowingly, paragraph A, make false statements of material fact or law to a third person, or B, fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6. Rule 4.2. Communication with persons represented by counsel. In representing a client, a lawyer shall not communicate about the subject of the representation with the person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or a court order. Rule 4.3. Dealing with unrepresented person. In dealing on behalf of a client with a person who is not represented by counsel, a lawyer shall not state or imply that the lawyer is disinterested. When the lawyer knows or reasonably should know that the unrepresented person misunderstands the lawyer's role in the matter, the lawyer shall make reasonable efforts to correct the misunderstanding. The lawyer shall not give legal advice to an unrepresented person other than the advice to secure counsel, if the lawyer knows or reasonably should know that the interests of such person are or have reasonable possibility of being in conflict with the interests of the client. Rule 4.4. Respect for rights of third persons. Paragraph A. In representing a client, a lawyer shall not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the legal rights of such a person. Paragraph B. A lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client and knows or reasonably should know that the document or electronically stored information was inadvertently sent shall promptly notify the sender. Rule 5.1. Responsibilities of a partner or supervisory lawyer. Paragraph A. A partner in a law firm and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has, in effect, measures giving reasonable assurance that all lawyers in the firm conform to the rules of professional conduct. Paragraph B. A lawyer having direct supervisory authority over another lawyer shall make reasonable efforts to ensure that the other lawyer conforms to the rules of professional conduct. Paragraph C. A lawyer shall be responsible for another lawyer's violation of the rules of professional conduct if 1. The lawyer orders or, with knowledge of the specific conduct, ratifies the conduct involved, or 2. The lawyer is a partner or has comparable managerial authority in the law firm in which the other lawyer practices, or has direct supervisory authority over the other lawyer and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Rule 5.2. Responsibilities of a subordinate lawyer. Paragraph A. A lawyer is bound by the rules of professional conduct notwithstanding that the lawyer acted at the direction of another person. Paragraph B. A subordinate lawyer does not violate the rules of professional conduct if that lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. Rule 5.3. Responsibilities regarding non-lawyer assistants. With respect to a non-lawyer employed or retained by or associated with a lawyer, paragraph A. A partner and a lawyer who individually or together with other lawyers possesses comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving reasonable assurance that the person's conduct is compatible with the professional conduct obligations of the lawyer. Paragraph B. A lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And, paragraph C, a lawyer shall be responsible for conduct of such a person that would be a violation of rules of professional conduct if engaged in by a lawyer if 1. the lawyer orders or, with knowledge of the specific conduct, ratifies the conduct involved. Or 2, the lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, or has direct supervisory authority over that person, and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. Rule 5.4, Professional independence of a lawyer. Paragraph A. A lawyer or a law firm shall not share legal fees with a non-lawyer except that 1. An agreement by a lawyer with the lawyer's firm, partner, or associate may provide for the payment of money over a reasonable period of time after the lawyer's death to the lawyer's estate or to one or more specified persons. 2. A lawyer who purchases the practice of a deceased, disabled, or disappeared lawyer may, pursuant to the provisions of Rule 1.17, pay to the estate or other representative of that lawyer the agreed-upon purchase price. 3. A lawyer or law firm may include non-lawyer employees in a compensation or retirement plan, even though the plan is based in whole or in part on a profit-sharing arrangement. And 4. A lawyer may share court-awarded legal fees with a nonprofit organization that employed, retained, or recommended the employment of the lawyer in the matter. Paragraph B. A lawyer shall not form a partnership with a non-lawyer if any of the activities of the partnership consist of the practice of law. Paragraph C. A lawyer shall not permit a person who recommends, employs, or pays the lawyer to render legal services for another to direct or regulate the lawyer's professional judgment in rendering such legal services. Paragraph D. A lawyer shall not participate with or in the form of a professional corporation or association authorized to practice law for a profit if 1. A non-lawyer owns any interest therein, except that a fiduciary representative of the estate of a lawyer may hold the stock or interest of the lawyer for a reasonable time during administration. 2. A non-lawyer is a corporate director or officer thereof, or occupies a position of a similar responsibility in any form of association other than a corporation. Or 3. A non-lawyer has the right to direct or control the professional judgment of a lawyer. Rule 5.5. Unauthorized practice of law, multi-jurisdictional. Paragraph A. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction, or assist another in doing so. Paragraph B. A lawyer who is not admitted to practice in this jurisdiction shall not 1. Except as authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law, or 2. Hold out to the public or otherwise represent that the lawyer is admitted to practice law in this jurisdiction. Paragraph C. A lawyer admitted to another United States jurisdiction and not disbarred or suspended from practice in any jurisdiction may provide legal services on a temporary basis in this jurisdiction that 1. Are undertaken in association with a lawyer who is admitted to practice in this jurisdiction and who actively participates in the matter. 2. Are in or reasonably related to a pending or potential proceeding before a tribunal in this or another jurisdiction if the lawyer or a person the lawyer is assisting is authorized by law or order to appear in such proceeding or reasonably expects to be so authorized. 3. Are in or reasonably related to a pending or potential arbitration, mediation, or other alternative resolution proceeding in this or another jurisdiction if the services arise out of or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice and are not services for which the forum requires pro hoc vice admission. Or 4. Are not within paragraph C2 or C3 and arise out of, or are reasonably related to the lawyer's practice in a jurisdiction in which the lawyer is admitted to practice. Paragraph D. A lawyer admitted to another United States jurisdiction or in a foreign jurisdiction and not disbarred or suspended from practice in any jurisdiction or the equivalent thereof, or a person otherwise lawfully practicing as an in-house counsel or under the laws of a foreign jurisdiction, may provide legal services through an office or other systematic and continuous presence in this jurisdiction that 1. Are provided to the lawyer's employer or its organizational affiliates, and not services for which the forum requires pro hoc vice admission, and when performed by a foreign lawyer and requires advice on the law of this or another U.S. jurisdiction or the United States Such advice shall be based upon the advice of a lawyer who is duly licensed and authorized by the jurisdiction to provide such advice. 2 are services that the lawyer is authorized by federal or other law or rule to provide in this jurisdiction. Paragraph E. For the purposes of paragraph D, 1. The foreign lawyer must be a member in good standing of a recognized legal profession in a foreign jurisdiction, the members of which are admitted to practice as lawyers or counselors at law or the equivalent, and subject to effective regulation and discipline by a duly constituted professional body or a public authority. Or 2. The person otherwise lawfully practicing as in-house counsel under the laws of a foreign jurisdiction must be authorized to practice under this rule by, in the exercise of its discretion, the highest court in this jurisdiction. Rule 5.6. Restrictions on rights to practice. A. A lawyer shall not participate in offering or making, paragraph A, a partnership, shareholders, operating, employment, or other similar type of agreement that restricts the right of a lawyer to practice after termination of the relationship, except an agreement concerning benefits upon retirement. Or, paragraph B, a lawyer shall not participate in offering or making an agreement in which a restriction on the lawyer's right to practice is part of the settlement of a client controversy. Rule 5.7. Responsibilities regarding law-related services. Paragraph A. A lawyer shall be subject to the rules of professional conduct with respect to the provision of law-related services as defined in paragraph B if the law-related services are provided 1. By the lawyer in circumstances that are not distinct from the lawyer's provision of legal services to clients, or 2. In other circumstances by an entity controlled by the lawyer individually or with others if the lawyer fails to take reasonable measures to assure that a person obtaining the law-related services knows that the services are not legal and that the protections of the client-lawyer relationship do not exist. Paragraph B. The term law-related services denotes services that might reasonably be performed in conjunction with and in substance are related to the provision of legal services, and that are not prohibited as authorized practice of law when provided by a non-lawyer. Rule 6.1. Voluntary pro bono service. Every lawyer has a professional responsibility to provide legal services to those unable to pay. A lawyer should aspire to render at least 50 hours of pro bono publico legal services per year. In fulfilling this responsibility, the lawyer shall, paragraph A, provide a substantial majority of the 50 hours of legal services without fee or expectation thereof fee to 1. Persons of limited means, or 2. Charitable, religious, civic, community, governmental, and educational organizations in matters that are designed primarily to address the needs of persons of limited means. And paragraph B, provide any additional services through 1. Delivery of legal services at no fee or substantially reduced fee to individuals, groups, organizations seeking to secure or protect civil rights, civil liberties, or public rights, or charitable, religious, civic, community, governmental, and educational organizations in matters in furtherance of their organizational purposes, where the payment